Good morning, afternoon, whatever time it is that you're watching this video. Welcome back to Supreme Court cases. So in this video today, we'll be talking about cases 17 through 24. In our previous two videos, we talked about cases 1 through 16. We're going to finish up our perusal of our landmark Supreme Court cases. All right, here we go. The first one is Hazelwood School District versus Coalmire. This is ruled on in 1988. The background here, for at least the 1980s, this particular decade was very conservative in American history. We're not quite as conservative as a society as we used to be, but in 1988, it was pretty conservative. Ronald Reagan was president at the time, and these students write two very controversial articles in the school paper. One regarding the divorce of someone who worked in the school newspaper's parents, which is something that you simply did not talk about in the 1980s. People did not get divorced. They just suffered through terrible marriages. And if they did get divorced, they certainly did not talk about it, and people definitely gossiped about them. So for Hazelwood School, sued a parent of one of the students who ended up writing the article about that. And then there was another one about a student who had an abortion. And this was a very conservative time. Again, we don't really talk about abortion in today's times because it's a very hot topic. It's a very heated subject, and people have very strong feelings on the subject. The same could be said in 1988. It was even worse. So for these things to be published in a public school newspaper, definitely not something that was allowed. So the principal suspends them, takes up all the paper. It was a lot, okay? The decision here, though, is that freedom of press is limited in schools, mostly because it could cause a disruption. So people were out here fussing back and forth, walking into class about abortion and about divorce and all of that, and whether or not we should be able to have either of those things available to us. And it was very disruptive to the school environment. So the decision here is that freedom of press, is limited in schools per the First Amendment. And moving right along, this next one is pretty wild. This one is Bethel School District versus Frazier in 1986. It was ruled on in 1986. The background, this man to the left is Matthew Frazier. He gives what's called a lewd speech at a school function. His best friend Jeff is running for vice president of the senior class. And so our little Matthew Frazier out here gives a ridiculous speech on behalf of his friend. And I'll read it to you really fast because it's wild. He says this, again, let's think about this. This is the 80s, a very conservative time, and this is also at a public school in front of a whole bunch of wild, negatively minded teenagers. He says out loud to teenagers in a room, "I know a man who is firm." I wonder what that could possibly mean. He's firm in his pants. Here we go. He's firm in his shirt. His character is firm, but most of all, his belief in you, the students of Bethel, is firm. Jeff Coleman, his best friend, is a man who takes his point and pounds it in. Good grief. If necessary, he'll take an issue and nail it to the wall. He doesn't attack things in spurts. He drives hard, pushing and pushing until finally he succeeds. Jeff is a man who will go to the very end, even the climax, for each and every one of you. So vote for Jeff for ASB Vice President. He'll never come between you and the best our high school can be. This individual stood up in front of a high school full of children and said this out loud. Okay, lewd here means inappropriate. That is certainly an inappropriate speech and definitely not one that needs to be given in front of a whole bunch of crazy, wild teenagers. So this typically works best when I say it out loud to a class full of students and they kind of just giggle and they're like, "Oh, I don't really know what to do about this," which is the same thing except for this time it was an auditorium full of kids. So the decision here for Bethel versus Frazier, freedom of speech in schools is limited if it is disruptive. Now, if you think back to the previous case that we discussed about freedom of speech in schools, Tinker versus Des Moines, when Mary Beth Tinker and her brother and some of their friends wore black armbands to protest the Vietnam War, the Supreme Court was completely fine with that because that was not disruptive. Matthew Frazier out here was being disruptive, and therefore his freedom of speech is limited at public school. And this is a result of the First Amendment. Moving right along to New Jersey versus TLO. This is ruled on in 1984. So if you notice, we have not had a set of initials before. We typically have either a state or a person versus a state or another person. Now, this is not the same because this individual was a minor at the time. So This girl's first name is Terry. We don't know the rest of her name, but her initials are TLO. So I'm sure if you looked hard enough in the state of New Jersey, you could probably narrow it down. So this girl is caught smoking a cigarette in the bathroom by a student, a school resource officer, and the vice principal comes down to the bathroom, and she is searched without a warrant at school. He looks in her bag, and she has a list of everybody that she deals pot and other individual drugs to. She has a list of their names, the time, the place, and how much they bought from her, and how much money it was worth. So this girl is a plug at school. She gets really upset because they don't have a warrant to search her bag. And we know, because the Fourth Amendment says that there is no illegal search and seizure, that you're supposed to have a warrant. However, that does not apply in a public school, because the privacy of one student does not overtake the safety of the others. So if the privacy of one student needs to be compromised in order to retain safety of the others, that is what needs to be done according to the Supreme Court. So, the decision here, students' right to privacy is limited in school based on the Fourth Amendment and its interpretation. So this is where we really start to see the Supreme Court interpreting the law instead of just reading it out loud. So they interpret the Fourth Amendment to say that your right to privacy can be infringed upon if and only if it needs to be trifled upon in order to maintain the safety of others. The next one is Texas versus Johnson. That's wrote on in 1981. So this man to the left, Gary Johnson, ends up burning an American flag at a political rally for Ronald Reagan's presidency, and he gets arrested. According to Texas Flag Code, Texas state law, you are not allowed to burn the flag unless it is a means of disposal in a respectful manner of a flag. Now, him being out on the courthouse steps in a little town in Texas is not necessarily a respectful disposal of a flag according to state law, so he gets arrested and tossed in the can. So the decision here, he's allowed to do that. He is allowed to use flag burning as a form of protest. He was protesting Ronald Reagan's presidency. He is a hardcore communist. If you see his shirt over here, this boy's kind of wild. So he doesn't really care, though. In general, he just kind of is out here trying to make a statement. He didn't say anything while he was burning the flag. However, it does give off a statement in itself, which is considered to be symbolic speech. And the Supreme Court in 1981, in a very controversial decision, ruled that flag burning is protected under the First Amendment as symbolic speech. Our next one is Furman versus Georgia. This one is ruled on in 1972. This man down here, Mr. Furman, has been charged with murder and issued the death penalty in the state of Georgia. Here's the problem. He robs a house, and when he's leaving the house, he says in his sworn statement, he takes his right arm, puts it behind his left shoulder, fires at the homeowner who is coming down the stairs of the homeowner's house and like, get out of my house, and is yelling at him, and he somehow hits him square in the chest while running away. That's his story, and that's what he stuck to. So, at the time, he was convicted, regardless of what his story was, he was convicted of murder. The jury found him unanimously guilty, and the judge sentenced him to death. Here's the problem, though. In 1972, only African-American males are being sentenced to death. That's not fair. So the decision here, according to the Supreme Court, is not about the death penalty itself, but about how it's being carried out. So they're saying that the death penalty is considered to be cruel and unusual punishment via the Eighth Amendment, if and only if it's not enforced fairly. Now, flash forward 4 years. This is a homie named Mr. Gregg. So Mr. Gregg stabs a man to death in the middle of the street in broad daylight, steals that man's car, and tries to get away. He gets arrested and tossed in the can. He gets convicted of first-degree murder as well, and he's given the death penalty 4 years after Mr. Furman. Here's the deal. He tries to appeal it because obviously he's not trying to go to the electric chair. Now, in the 4 years since Furman versus Georgia has been decided upon, they have gotten their life together in the state of Georgia, at least a little bit with regards to the criminal justice system, and now they are applying the death penalty to people of all races and not just African American men. So, by the time Mr. Gregg gets to the Supreme Court 4 years after Mr. Furman does, all right, the death penalty is constitutional if it's applied fairly according to the Supreme Court and the Eighth Amendment. Now, some conclusions to the story here. Mr. Furman, after he was acquitted, because his first trial, he got sentenced, and then he went to Supreme Court, and then he was brought back on a second trial. So the first trial was declared a mistrial, and then he got brought back a second time for murder charges and was acquitted, which means he was found not guilty. So, after he was found not guilty, he said out loud, "Yes, I did kill that man in cold blood." So sometimes the whole system of being appealing and getting a conviction or an acquittal, sometimes it does not work out for the best because a murderer is walking free currently. All right, and Mr. Gregg, he ends up escaping from prison while awaiting his death sentence on death row. However, he gets into a giant bar fight and gets shivved. So not so much for him. Not shivved, sorry, not. He didn't get shivved. Another guy did later on. But he ends up getting in a bar fight, and he smacks the back of his head on the side of the bar, and his neck snaps as a result. So was justice served? I don't know. That's for you to decide. Let's go back just a little bit to Roe versus Wade. This happens in 1973. This woman here on the left, her pseudonym, or kind of her fake name, is Jane Roe because she doesn't want her real name out and about. She was denied an abortion because of Texas state law, and she decides to sue the district attorney of Texas. So here's the deal. Homegirl has got 2 kids already and is pregnant now for a 3rd time. Neither of her 2 children actually reside with her. One resides with her aunt and one resides with her grandma. So she's not actually raising either of her 2 children because she is not able to do so either mentally or physically for a host of reasons. Now the 3rd time she gets pregnant, by the time this case gets decided, she's already had this baby. Okay? That's how long it takes. It is not a 9-month like quick, fast, in a hurry process. That's not how it works. So she ends up having the child in the meantime and gives the child up for adoption. The decision here is that abortion is legal. This is one of the most controversial Supreme Court cases of all time. It is legal and it's protected by both the 9th and 4th Amendments. They kind of team up and they together provide you with the right to privacy according to the Supreme Court. Next is Miranda versus Arizona. This man, Ernesto Miranda, is the reason that we have Miranda rights, okay? We have rights in general, but we call them Miranda rights because of him. This case is ruled on in 1966. So this man, to the right here, Ernesto Miranda, was charged with the kidnapping, rape, and murder of a 16-year-old girl, all of which he did commit. All right, so he's never read his rights, but he's a career criminal. He knows what his rights are, but he's not read his rights, and he doesn't bring it up, and he manipulates the situation, and he confesses to kidnapping, raping, and murdering this 16-year-old girl. So here's the problem. Once he does call his attorney, he's like, hey, they never read me my rights, and his attorney is like, I got you. We about to get out of here. So the decision here is that any statements that you make before your rights are read to you or told to you, typically by a cop, are not admissible in court. You are not allowed to bring up any conversations in court that were said out loud before they read you your rights. So Ernesto Miranda's out here like, yes, I killed this girl, but he was never told that he had the right to remain silent. Anything you say can and will be used against you, yada, yada, yada. And so it was not admissible in court. Here's the deal, though. All of the physical evidence was able to get him convicted. He ended up being sentenced to 20 to 30 years in prison and was killed. He was shivved while in prison. So there is that. All right. And this mugshot here is from 1967, so a year after his Supreme Court case. So he was acquitted the first time because he couldn't have that held against him. He went to court the second time, and then he was eventually convicted of that. All right, and that has been part 3.